For an asset purchase, diligencing and identifying the IP was crucial, but for a stock purchase, diligencing and identifying the liabilities is what's crucial. And so you as the buyer want to know all known and suspected infringements and any third-party IP monitoring practices. And this would, again, have to be balanced with the risk of treble damages for any willful infringement. There most likely will not be indemnification post-closing for any breach of any rep and warranty relating to IP infringements, particularly if the transaction is a merger where there's no surviving entity, since you won't be suing yourself, or if there's reps and warranties insurance, in which case most likely the seller won't give any indemnification. For post-closing arrangements, it's the same considerations as with an asset purchase, the wind down and the license back. For a stock purchase, the difference between owned and licensed IP is not as important as it is for an asset purchase. And that's because both the IP itself and the licenses would come across without a change in the identity of the licensee. So consent would not be required because the identity of the licensee has not changed. But there is an important carve-out. If the IP license includes a change of control provision, so if consent is required for a change of control, the stock purchase will probably trigger the requirement for consent. There are certain integration issues that are specific to stock purchases. One is whether the material agreements will be covered by the combined business. Will cover what will be the combined business post-closing, because otherwise that IP can only be used and siloed for that particular subsidiary within a larger group, which is not ideal. You also want to consider whether any restrictive covenants that the seller or the target has agreed to will cover your business, your entire business post-closing. So for example, if your buyer has agreed to a non-compete that covers all of its affiliates, post-closing you'll be an affiliate and therefore subject to the non-compete, so it may actually be advisable to walk away from that kind of transaction.